Court does call the case of the people of the state of Michigan versus Andrew Krupar.
What you're watching here is not a dramatic jury trial. It's something just as powerful. The gateway stage of felony prosecution. One after another, defendants are stepping up to decide whether to demand a preliminary examination or waive it and move directly to circuit court. That decision matters. A preliminary exam forces the prosecution to show probable cause, meaning there's enough evidence that a crime likely occurred and that the defendant likely committed it. It's not proof beyond a reasonable doubt, but it's the first real stress test of the case. And here's what's critical. Waiving this hearing is strategic. It can signal confidence, negotiation behind the scenes, or simply acknowledgement that the evidence is strong enough that fighting now changes nothing. Watch how many defendants choose to waive. Watch who asks for time. Watch how bond conditions remain or shift. These quiet procedural moves shape the entire trajectory of a case long before a jury ever hears it. This session isn't loud, but it's decisive.
Morning, Your Honor. With us, on behalf, not with, but on behalf of Mr. Krupar on both cases.
All right, Mr. Krupar, can you state your name, please?
Stephen Rizzo Krupar.
All right.
And we are good to go forward as we discussed next session. We're waiving exam, Your Honor.
On both of these cases?
Yes.
All right. Mr. Krupar, you're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
All right. Preliminary examination having been waived, defendant is bound over to circuit court on all 8 counts as contained in the case ending in 5689 and on the single count in the other matter. Mr. Downs.
Now, should we copy of information by further reading and statement?
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all charges. Pre-trial in these matters will be set for
April 29th at 1:30 before Judge Simpson.
April 29, 2025, 1:30 before Judge Conkey. Bond will continue in these matters. Thank you.
Thank you.
Court does call the case of the people versus Jerry Ashley.
Andrew Childers, declared on behalf of the people now.
And good morning, Your Honor. Just to tell you, the Richard on Jerry, I really on behalf of Mr. Jerry Ashley, who is on to Judge.
Oh, there he is. Mr. Ashley, can you state your name, please?
Yes, sir. Jerry Ashley.
Thank you. What are we doing?
Your Honor, today is the date and time set for preliminary examination for probable cause conference. Mr. Ashley would like to waive his right to a preliminary exam and ask that this matter be set for pre-trial in circuit court. That has been an offer extended by the people.
And is a waiver part with that offer? Or
I didn't hear you, Judge. I'm sorry.
did somebody want to put the offer on the record prior to the waiver?
Your Honor, I did email Mr. Ashley is serving an MDOC sentence. Effectively, the offer would be to please on this file, we appreciate the current MDOC sentence. I think that something around 24 months to 15 years. I believe it's like 33 months to 10 years on this current sentence.
Got it. All right. All right. Mr. Ashley, you're waiving your right to a preliminary examination?
Yes, sir.
Another waiver. But with added context, the court mentions Mr. Ashley is already serving a sentence elsewhere. That changes strategic calculus. When someone is already incarcerated, the urgency to fight probable cause may decrease. The defense might decide resources are better spent negotiating the bigger picture rather than forcing a short preliminary hearing. Still, the judge confirms understanding. You're giving up the right to require the state to show probable cause. The answer is yes. Bind over to circuit court. Not guilty plea entered automatically when standing mute. Pre-trial scheduled. Bond continues. It sounds procedural, but every waiver narrows tactical options. If you were already serving time and facing a new charge, would you demand an early evidentiary preview or conserve energy for negotiations? These decisions aren't emotional, they're strategic.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Ms. Ackenrose.
Yes, Your Honor, he does waive formal reading of the complaint, stand mute, and of course, enter a not guilty plea.
Defendant every waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
May 7th, 1:30 before Judge Conlon.
May 7th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you.
Court does call the case, People versus Krista Riopel.
Echelon of the people. I present public defender to carry out the ruling on behalf of Mr. Riopel. Ms. Riopel, could you state your name for the record?
Krista Riopel.
And Your Honor, we're asking for an adjournment in this matter. We have received the dates to meet with Ms. Riopel, so I'm very hopeful with that.
You have what, say again?
We received the date, our social work department has finally been granted permission to meet with Ms. Riopel, so hopefully we'll be able to get that information.
All right. Probable cause conference without objection, May 1st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Court calls the case of the People versus Stephen Bauer. I was coming out. Is that all my?
That is your call, your palace, yes, sir.
Good morning, Your Honor.
Well. How are you?
I'm well. How are you?
I'm doing great. Welcome back. I was gonna say, look what the cat drug in, but that would be inappropriate. Mr. Burgess.
Good morning, Your Honor. May it please the Son of Loophole. David Burgess on behalf of Stephen Bauer.
All right. Your name, sir?
Stephen Bauer, sir.
All right. What are we doing on this case?
Your Honor, I've advised my client of his right to an exam in this matter. He's choosing to voluntarily waive that right and have his case bound over to circuit court for further proceedings.
Is that correct, sir?
Yes, Your Honor.
You understand that? Oh,
I'm sorry to interrupt.
No.
Prior to a waiver, I don't believe that discovery has been turned over in this case yet. We don't have an appearance from Mr. Burgess, so before I was comfortable waiving preliminary.
you don't?
Judge, I filed an appearance at the arraignment on the warrant.
We did not, our office did not receive an appearance or discovery request from Mr. Burgess.
Oh,
If that's not the case, Judge, I'll fix it today.
pardon?
If that is not the case, I'll fix it today, but I did appear at the arraignment on the warrant.
Okay, but you guys have the discovery or no? I guess the question is whether or not this is going to be a knowing waiver, given if the discovery hasn't been turned over.
This is a key safeguard moment. The court pauses because discovery may not have formally been turned over. You cannot knowingly waive a preliminary examination if you haven't seen the evidence. That would undermine the integrity of the waiver. The defense confirms discovery has been received and discussed. That satisfies the court. This shows the judge isn't just processing paperwork, he's protecting due process. Then comes the tablet issue. The defense wants the defendant to access commissary and video visits despite an internet restriction bond condition. The judge refuses to modify the bond without proper procedure. That's restraint. Bond conditions are about risk management, not convenience. If there's an internet prohibition, the court won't casually alter it. Even small bond details impact daily life. But courts move carefully when modifying supervision conditions.
Your Honor, I have discovery in the case, and I've discussed it with my client as well as Mr. Kennedy from the prosecutor's office, and he's aware I was waiving today. Made him aware already.
I have his appearance. Pardon?
As long as he has discovery, then I would be comfortable with waiver.
Yeah, I have his appearance entered on March 20th or 26th. Okay. All right. And so you're comfortable waiving preliminary examination given that discussion?
Yes, sir.
All right, and you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right?
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts. Mr. Burgess.
Your Honor, we'd waive any reading of the information standing as the charges contained within.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial will be set for
April 24th at 1:30 before Judge Slay.
April 24th, 2025, 1:30 before Judge Slay. Bond will continue.
Thank you. Your Honor, there was one matter. I'm sorry, Judge. Judge,
Yes.
he doesn't have access to his tablet at the jail just for commissary and video visits. I don't know why there's an order not using the internet, which I understand, but I just want him to be able to use his tablet while at the jail to get commissary and video visits with his parents.
Because he should not have any access to the internet. I believe he would have access to the internet via that tablet.
I don't know. We had some, in another matter, there was some discussion about that. I'm not going to change the bond condition. You can check with the jail. My understanding is there is something regarding the tablets that there is not internet access, but I'm going to leave that to the two of you to check with the jail, understanding the objection and the request of the defendant, and then you can put an order before Judge Slay. But I'm not changing it at this point. All right? Thank you.
Sure.
Court does call the case of the people versus Alan Payne.
Ready, Your Honor.
Speaking of pain, I mean, no, I'm sorry. I'm sorry. I'm sorry. That just kind of came.
Wondering how you were going to improve it.
Especially like people.
Trying to show something we have.
All right, you're requesting your name, sir?
LP.
Thank you. And you're requesting an adjournment in this.
I proposed a resolution to bond that needs some more support. So yes, sir.
All right. How much time are you going to need to do that?
Roughly 3 weeks-ish.
All right. Without objection, probable cause will be adjourned May 1st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of people versus Kurt Burke.
Morning, Your Honor. Christie Stone on behalf of Mr. Burke, who's coming out right now, standing for the attorney of record, Dan.
Wow.
Kurt William Burke.
All right. And you have no objection to Mr. Eastrom standing in for Mr. Beers?
I'm part of the hearing. Your Honor.
Oh, okay. Do you need, hang on, let's get you some equipment. So you. Can you hear me now?
Yes, sir.
All right. You have no objection to Mr. Eastrom standing in for Mr. Guerin today?
I do not.
All right, very good. All right. You're requesting an adjournment in this case?
For 1 week, he had another case scheduled already for next week, Your Honor, so we'll just ask him for-
Oh, okay. So to get the cases together. All right. Probable cause conference will be adjourned then to the 17th, April 17th, 2025, 9 a.m. Bond will continue. All right, thank you. Court calls case people versus Cyrus Abadi. Is that it for you, Mr. Eastrom?
No, I won't.
Okay.
You know, once Tanhouse case gets to check off. I think
Or will there have to be both describing this one?
Good morning, Your Honor. Good afternoon. On behalf of Cyrus Abadi, Secretary.
All right.
Before public cause conference, there's a request for a legal transfer for discovery and some information.
No objection.
Okay, thank you. That's okay. You took care of it, Ken, huh? Hello, good morning. And they're requesting an adjournment. There's no objection, I presume.
Your Honor, we're not being clarification violation.
Probable cause conference, May 1st, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case of People versus Ashton Dew.
Ashton Lund, the people.
Ready. Your Honor, Philip, on behalf of Mr. Dew. Your Honor, there is a waiver before you, but let me give a little context.
Okay.
We were here, the probate attorney did go back to the circuit court, and the circuit court refused issuing one ordinance. Yes, I know, and I know the court's been helpful. So wait, we've done some work on our end. We hope the court will adopt. My client's grandmother is here. She's the.
So he never got it right.
That is correct. But we've done some work here. I know, believe me, I know. My client's grandmother was whom my client resided. She was the whistleblower. And so I'm telling you that for a reason. What the parties have agreed to, and that we hope the court will agree, is that my client's going to waive his right to preliminary examination. We're going to ask the court to amend the bond by our agreement to change it from a $50,000 10% to a $25,000 10% bond, keeping the GPS condition of the bond, GPS tether.
Now this is meaningful. Reducing a 10% bond from $50,000 to $25,000 cuts required cash from $5,000 to $2,500. That's substantial relief, but it's not being requested without structure. The defense proposes continued GPS monitoring, residence with the grandmother, outpatient mental health treatment, and a signed release so community corrections can verify compliance. That's strategic mitigation. Bond is not punishment. It's about flight risk and community safety. By offering structured treatment and supervision, the defense is presenting a controlled environment. The grandmother being described as the whistleblower adds credibility. It suggests oversight rather than concealment. If you were the judge, would structured treatment plus GPS justify reducing bond by half? This isn't emotional appeal, it's risk calculation.
My clients agreed to go back home and reside with his grandmother, to abide by her household rules, and most of my client's grandmother has, through his insurance, arranged for a referral from his primary care physician to an outpatient mental health treatment program. The waiting list is, the shortest one she can find is 1 to 3 weeks, but my client must voluntarily make that referral or follow through on that referral. So that would be a condition of his bond. And then another condition of his bond would be to sign a release of information to update community corrections that was doing exactly what he's supposed to be doing.
All right. Is that a correct statement on?
It is, Your Honor.
Okay. So am I going to get an order to that effect?
I can make that happen, certainly.
Okay. Why don't we do that? And then I just won't sign because I lose jurisdiction. So I need that today if we could.
It'll be done by the close of the morning for sure.
All right. Very good. Okay. So I'm not going to do it that way.
If I know Miss Yu, she's watching this on you. Is this on YouTube?
Sure.
Then she's making it happen while we're talking.
Is she? Then I'll just wait. Given how efficient she is, it will be coming to us any moment. We'll wait for the 10-second delay and then it will show up. All right. So he's going to waive preliminary examination.
Yes.
All right. Is that correct, Mr. Dew?
That's right.
All right. And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
That's right.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Another bind over. Another automatic not guilty plea when standing mute. Standing mute is procedural protection. If a defendant does not verbally plead, the court enters not guilty to preserve rights. The bond continues pending formal entry of the amended order. Notice how the judge insists on receiving documentation immediately due to jurisdiction concerns. Once a case advances, authority shifts. This level of procedural precision prevents future disputes, and strategically, agreeing to treatment and GPS early can build credibility for plea negotiations later. This wasn't dramatic, but it was calculated.
Mr. Simon.
Sorry, Your Honor, wait formal reading of the information stand.
Defendant every way formal reading standing mute to both counts. Court will enter not guilty plea. Pretrial will be set for
April 24th at 1:30 before Judge Slade.
April 24th, 2025, 1:30 before Judge Slade. Bond will continue. Well, bond will continue at this point, and then I'll sign the order.
Thank you, Your Honor.
Is anything coming over rather than send it out? Court calls the case of the People versus Christian Leo.
So the attorney here to the people.
And good morning, Your Honor. For the record, Brian Stacy on behalf of Mr. Leo, P33014.
Good morning, sir. Mr. Leo, can you state your name, please?
Christian John Leo, Your Honor.
Thank you. All right, what are we doing?
Judge, at this time, my client recently was released from the Oakland County Jail because this charge violated his probation. And but at this time, he wishes to avail himself of having a preliminary examination in this matter.
Now we see a different move. Unlike earlier defendants, this one demands a preliminary examination. That means witnesses will testify and the prosecution must present evidence in open court. Why demand it? Possibility 1, the defense sees weaknesses in the state's case. Possibility 2, they want early cross-examination to lock witnesses into sworn testimony. Possibility 3, probation violation exposure raises stakes and they want leverage. Discovery is confirmed complete, meaning the defense is not walking in blind. Demanding a prelim is a signal. It says, we're prepared to test this case. Would you force the state to show its hand early or wait? This case just became adversarial.
Is all discovery complete?
Yes, Judge, as far as the defense is concerned.
People have their witnesses available April 22nd. All right. Preliminary examination in person will be set April 22nd, 2025, 9 a.m. before Judge Freshour.
Judge, okay, and what location would that be, Judge?
It'll be right here at this location where I am.
Okay, and Judge, I have one housekeeping matter. The Washtenaw County Community Corrections, the bond release in Oakland County, I have the order in my hand. It says that the defendant will maintain wearing the GPS tether until further order of the court. So Oakland County is aware that he's wearing your tether, but apparently the Washtenaw County Community Corrections wanted it to be okay that you're all right with Mr. Leo only having the one tether. He's on $100,000, 10% tether with you, and he's been wearing the tether with you for over a month now. But apparently, I've never heard of this before, but the Community Corrections wanted you to be aware of that and that you're okay with that.
But he's wearing the tether at this point pursuant to our order.
Yes, that's accurate, Judge.
All right. And I guess, yes, how do they want it communicated that I'm fine with that? I mean, as long as he has the tether on. I don't.
Well, no, I'm assuming that as long as you know Community Corrections doesn't have an issue, we could ask Mr. Leo. He was the one advised of this. I've never heard such a request. Christian,
go ahead, Mr. Leo.
So I was released from Oakland County with their Oakland County tether. They informed me upon release to get in touch with the Washtenaw Corrections regarding a Washtenaw tether possibly. And then once I reached out to that agent, he said to just make sure it was okay with the courts that I have the one GPS tether from Oakland County. Now, the Washtenaw Community Corrections guidelines where I'm not supposed to be at the victim's house is already implemented into my Oakland County tether. So it's all like 2-for-1 type deal going on, if that makes sense.
Okay, now that makes sense to me. And that's why Community Corrections is asking, because otherwise what they will do, since his tether that he has on currently is an Oakland County tether, if it's not okay with me that he wears that Oakland County tether, then they're going to put another tether
Correct.
on our case.
Yes.
And we do that out of efficiency and because he has two legs. No. So I don't, and the Oakland County order indicates, all right, why don't we do it this way? Somebody prepare an order just indicating that the defendant is, that the tether provision for Washtenaw County will come into effect if he's released from the Oakland County tether. So that he only has, the purpose of that is that he only has to wear one tether.
This tether discussion may sound administrative, but it's important. Without coordination, the defendant could be required to wear 2 GPS devices simultaneously from 2 counties. The judge creates a practical solution, 1 tether at a time, with automatic activation of the second if the first is removed. That's efficient supervision. Then the defendant flags removal from drug and alcohol monitoring. That's risky. If monitoring lapses unintentionally, it can appear as non-compliance. The judge orders reinstatement to protect the record. Compliance infrastructure matters. Administrative confusion can cause violations even when someone intends to follow rules. Procedural clarity prevents future bond problems.
But the moment, if for whatever reason Oakland releases that tether, he has to come to community corrections to have our tether placed on it.
Okay, so if the tether ends in Oakland, then he's to get the tether in Washtenaw.
Yes, sir.
Okay, great.
He's to immediately report to community corrections for placement on our tether.
Right.
And then another thing, Your Honor, the supervision agent had also mentioned that I had to bring up, I guess they have me out of the system now for the drug testing and alcohol monitoring as well. That was part of the tether deal. So I just want to mention that to you. Maybe we have to put an order in to get me back on that list. I just want to comply with my bond. I don't want to have any hiccups there.
So they took you out of the system for the testing portion of it.
Yes, that as well.
All right. I need to look at it. I'll just enter a new order. We'll get you back on the system.
Okay. So
Okay.
you want me to give a call to Washtenaw Community Corrections?
We'll be doing that within the next, how long is it gonna take? Oh, it's already in your hand. Probably in the next 30 minutes at most.
All right. I'll give them a call
All right.
later on and I'll
Yeah, call over there
away.
and once they receive the order, they'll get you back in line on that.
All right, sounds good. I appreciate your time, Your Honor.
Not a problem. All right. And Mr. Stacy, you'll send over the other order to us, correct?
Yeah, that's accurate, Judge.
All right. Thank you, folks.
Okay, and Judge, where do I send the other to your courtroom then?
Pardon?
I'll send the order to your court reporter or to your courtroom.
Yes, that's fine.
Right. Okay, thank you, Judge.
Thank you.
Thank you, Your Honor. Have a good day.
You do the same, sir. Court calls the case, People versus Devin Gibson.
And then on behalf of the people, Your Honor.
Yes, Your Honor, please, for Brendan Bird on behalf of Devin Gibson.
Good morning, sir. Your name, sir? Thank you. All right, you're requesting an adjournment.
President adjournment, Your Honor. That, make sure we have all discovery. It's found out today that my client's getting arraigned on June 4th, at 1 o'clock.
And that's correct, Your Honor. There was a warrant from February this year that I authorized last night for a home invasion first, a DV, and an assault. And that's up on the arraignment docket today at 1.
Now the temperature shifts. A new warrant surfaces. Home invasion first degree, assault charges. That's a serious escalation. When fresh felony charges enter mid-proceeding, everything changes. Bond exposure, sentencing risk, negotiation leverage. Notice defense counsel immediately requests time to ensure all discovery is complete. That is not delay for convenience. It is protection. You cannot advise a client intelligently when new allegations are still unfolding. The judge coordinates scheduling so both matters align procedurally. That prevents fragmented hearings and inconsistent timelines. Strategically, new violent felony allegations strengthen prosecutorial leverage. But they also increase defense urgency to evaluate weaknesses quickly. When a case expands unexpectedly, momentum shifts. The question becomes, does this harden the state's position or create pressure to resolve everything globally? The calm tone masks the seriousness of what just happened.
Are you going to represent him on that? Or do you know? Okay. Then I'll just let it flow through. Otherwise, I was going to go grab the file and do it. But, all right. So if he's arraigned on that today, they're going to set 24. All right. So probable cause conference in this matter will be adjourned to April 24th, 2025, 9 a.m. Bond will continue in this case. All right. And what we'll do, counsel, in case that's how it's going to be done, we'll notify them that we've set this one over so that when he's arraigned, they'll set the PCC for the same day. All right. Thank you.
This is structured docket control. The court is preventing procedural chaos by aligning probable cause conferences with arraignments. When multiple cases run on different tracks, confusion increases, and confusion breeds mistakes. By synchronizing dates, the court ensures consistency in bond review and case management. From a defense standpoint, consolidated scheduling can help coordinate strategy. From a prosecution standpoint, it prevents contradictory rulings or overlapping hearings. Efficiency in criminal court is not cosmetic. It protects record integrity. And notice again, bond continues. That means, despite new allegations, the court does not immediately increase restrictions at this stage. That's significant. Bond determinations are about risk, not punishment. The court sees no immediate reason to alter supervision conditions. We, for now,
You do the same. Court calls the case of the people versus Cameron Hanlon.
Morning, Adam. Good afternoon. Gary Cameron.
Thank you. Yes. And I've signed the substitute. All right. We put your other case to the first. Did we put your other case to the first?
We did, yes.
Okay. Without objection, probable cause conference will be adjourned May 1st, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case People versus Daryl Hicks.
Morning, Honor Sam Bernstein with on behalf of Mr. Hicks.
And that's all. All right, go ahead.
Your Honor, asking to proceed to examine. I'm all set on discovery.
People have their witnesses available the 22nd.
here we return to cases actively proceeding to preliminary examination. When the prosecution confirms witness availability, that signals readiness. A prelim requires live testimony. The state must present enough evidence to satisfy probable cause through sworn statements. This is where cases are stress tested. Unlike waivers earlier in the session, this defendant is not conceding the probable cause stage. That means defense counsel will cross-examine witnesses. Even limited cross at this stage can expose weaknesses or preserve impeachment material for trial. Setting an in-person preliminary examination underscores seriousness. No remote shortcuts, no procedural bypass. If the prosecution's evidence is strong, bind-over will be routine. If testimony falters, leverage shifts dramatically. Demanding a prelim is controlled confrontation. This is where quiet cases become contested.
All right. Preliminary examination in person, April 22nd, 2025. 9 a.m. before Judge Freshow. Bond will continue. Thank you. Court calls case People versus Axel Saldivar. It is.
Trustee, on behalf of Axel Sanchez, so.
Your name, sir? Okay. You're requesting an adjournment.
Your Honor, Mr. Childers and I have spoken, we're asking for, the client to sign a waiver, we're asking to put the case out until later May if possible, there's a lot to do on this case, so, I don't believe people have any objection. We certainly don't.
But what if I do? What happens?
That was me.
Okay. Do people have any? That'll work. Probable cause conference set May 22nd, 2025, 9 a.m. Bond will continue.
Another adjournment, but not without subtle judicial control. When the judge responds earlier with "but what if I did," in response to presumed lack of objection that reinforces authority. Adjournments require judicial discretion. Delays impact witnesses, victims, and defendants. Memory fades, pressure builds, strategy evolves. Defense indicates there's a lot to do on this case. That often signals complexity, possibly forensic review, document volume, or negotiation groundwork. Time can help either side. For defense, preparation strengthens argument. For prosecution, extended timeline may increase pressure. The court balances fairness with momentum. Every continuance carries tactical implications beyond the calendar date.
All right, thank you.
Thank you very much.
All right. Court calls case People versus Don Miguel Lee.
Anderson on behalf of people.
Is this? This is an old one too?
Yes, sir.
I don't need the old one. All right, go ahead.
Your Honor, we're ready to proceed.
State your name, please.
All
All
right. Ready to proceed to exam, Your Honor, with all set on this.
right, on both cases.
Yes, Your Honor.
People have their witnesses available the 22nd.
For best, Your Honor.
So. Preliminary examination in person will be set April 22nd, 2025, 9 a.m. before Judge Washington on both matters.
Thank you, Your Honor.
All right, bond will continue. Thank you.
Today's proceedings demonstrated how criminal cases advance through calculated procedural decisions. Multiple defendants waived preliminary examinations, allowing their cases to move directly to circuit court without forcing the prosecution to establish probable cause in open court. In several matters, bond conditions remained unchanged, reflecting judicial confidence in existing supervision. In one significant case, bond was reduced in exchange for structured mental health treatment, GPS monitoring, and verified compliance, a clear example of mitigation influencing judicial discretion. Other defendants chose to proceed with preliminary examinations, signaling readiness to challenge the state's evidence through live testimony and cross-examination. Meanwhile, AI administrative complexities, including multi-county GPS tether coordination and discovery timing, were addressed to preserve procedural clarity. No final rulings were issued today. Instead, the foundation was laid. The real evidentiary battles are scheduled ahead. These early strategic moves often shape plea negotiations, sentencing exposure, and trial posture long before verdicts are rendered. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.